Dear distinguished guests, dear ladies and gentlemen, and young people, I greet you very warmly and I'm happy that you are here today. And I will talk about something about the judge system in Croatia. Family law in the Republic of Croatia has changed a lot in the last 10 years, counting from the entry into force of the Family Act on November 1st, 2015. The Act introduces clear procedures for protecting children's right in divorce, parental responsibility, child support, child protection measures, and adoption. It also brought new ways of resolving family disputes outside of the court, mandatory counseling and mediation, and strengthened the protection of children's rights by establishing the Center for Special Guardianship. This institution represents children in proceedings in family law matters. I should change it first. What's now? Oh, sorry. This Family Act puts the child's best interest in the first place. Under this act, the child is a sui generis party, represented by a special guardian, and has the right to express his or her opinion. In any proceedings regarding child's personal property rights and interests, the court must allow the child to express its opinion in appropriate place and, if needed, in the presence of a professional. The child must be informed about the subject, progress, and possible outcome of the proceedings in a way that suits the child's age and maturity, as long as this does not harm the child's development, upbringing, or health. Depending on the case, the duty to inform the child lies with the special guardian, the court, or a professional from the Croatian Institute for Social Work. The court must ensure that this duty is fulfilled. Under the regulation of obtaining a child's opinion, the court must allow the child aged 14 or older to express an opinion independently. A child under 14 may express an opinion through a special guardian or another professional. The child always gives their opinion without the parents or caregiver being present. After the Family Act began to apply, a larger number of family disputes started being resolved outside the court, about 65%, while fewer cases, 35, are handled in the court. In Croatia, there are 34 municipal courts and 70 permanent court units. There are also 15 county courts as well as 4 permanent units. In 2024, there were 1,660 judges working in all Croatian courts. As in previous years, most judges were women, 1,206 of them, that makes 72%. Only at the Supreme Court, the situation is reversed. 31% were women and 69 were men. Until 8 February 2022, all municipal courts handled family cases. With the amendments to the Courts Act, effective from March 1st, 2022, only municipal courts located in the seats of county courts, plus the municipal court in Novi Zagreb, become competent to handle family cases for the area of each county court. From the 1st January 2019 until 28 February 2022, appeals in family law cases were handled by only 3 county courts, Pula, Split, and Zagreb, and that was a very good solution. That means that from March 1st, 2022, municipal courts became specialized for family cases, but county courts lost that specialization. The President of the Supreme Court described this as a contradictory in the 2024 report on the state of the judiciary. The 3-year specialization of county courts in family cases helped make court decisions more consistent and improved legal certainty, which is important both for the first instance courts and for the parties involved. Consistent court decisions are an important part of legal certainty, which is essential for the rule of law, protecting people's rights and the public interest. Therefore, first instance judges nowadays support bringing back specialization of county courts in family matters. Although my topic is family courts, Croatia does not have separate family courts. Instead, family cases are handled by special departments within certain municipal courts. Amendments to the Court Act, effective from 1st March 2022, introduces family departments in the assigned municipal courts. According to the Court Acts, judges assigned to a family cases must have a strong interest in children's needs and welfare, possess basic knowledge of social pedagogy, youth psychology, and social work, and regularly attend professional training. From 1st January 2026, this rule will also apply to county courts. Until the end of this year, judges handling family cases are appointed by the President of the Supreme Court for a period of 5 years. After that period, they can be reappointed. But this legal provision will be removed on the 1st January next year. From 1st January next year, presidents of municipal and county courts will, to the court's annual schedule, assign judges to work on family cases. The Minister of Justice was supposed to issue a rule book on the training program for judges handling family cases by 1st September 2022, but that was never done. From 1st January next year, the President of the Supreme Court will set the training rules instead. Since Croatia has 50 county courts, that means that 50 municipal courts located in those cities, plus municipal court in Novi Zagreb, handle family cases in the first instance. That makes 60 municipal courts in total. Family departments in first instance courts also include experts, associates, psychologists, who help judges in cases requiring expert knowledge. Of the 16 competent municipal courts, only courts in Bjelovar and Šibenik currently do not have psychologists, but hiring procedures are ongoing. However, some courts use psychologist help extensively, while others use it very little. A major problem is the lack of rule book defining the psychologist's exact duties. For example, in proceedings involving juvenile delinquency, there is a rule book on the work on non-legal experts associated with a long name, which has been in force for 12 years and clearly and precisely defines the task performed by an expert associate. The Civil Procedure Act in Croatia defines evidence, such as the documents, witness statements, hearing of the parties, expert reports. Since psychologists are not court experts, their reports do not have the same probative value as expert evaluation, which is why their role is not used in full. The family cases, you can see, on municipal courts look like you can see in the screen, maybe. Sorry. Okay. A total of 74 judges handle these cases across all municipal courts. In all family proceedings involving a child, the authority must act quickly in order to protect the child's well-being. Courts must act without delay in all proceedings concerning a child's status, decision on parental responsibility, the child's personal relationships, such as a contact with the parent the child does not live with or with the close relatives, safeguard measures, and enforcement proceedings. Legal deadlines in those family cases are very short. In these proceedings, the first hearing must be held within 15 days from the start of the procedure. If a decision is made without holding a hearing, then it must be issued and sent within 15 days from the start of the procedure. In proceedings of temporary measures and enforcement related to the parental responsibility, contact, or handing over the child, the decision must be issued and sent within 30 days. In this case, the second instance court, county court, must issue and send its decision within 30 days of receiving the appeal, unless the Family Act provides differently. For example, in Article 295 of the Family Act, it sets a 3-day appeal period and 50-day deadline for the county court to decide on the appeal. These time limits may be exceeded for important reasons. If a deadline is missed, the judge must submit a report explaining delay to the court president. I have never heard that happening, but it might have happened. All these rules show the legislative intention to speed up proceedings concerning children's rights, proceeding rights as much as possible, especially when the child is particular risk. However, sometimes it's not possible to meet these deadlines due to various subjective or objective circumstances. In a large number of family cases involving minors, children are represented by special guardians employed in the Center for the Special Guardianship, which has its headquarters in Zagreb and 7 regional units. The center employs 26 special guardians, people who graduated in law as passed bar exam, which is a relatively small number considering the amount of cases and the size of a territory they cover. For example, in the region of Istria, which has almost 200,000 inhabitants, the duties of a special guardian are carried out by only one person. Much more about this institution will tell you my colleague in the next presentation. Some legal experts argue that Croatia should establish separate family courts handling family law and juvenile criminal cases. However, with a population of 3.8 million, Croatia does not have enough cases to justify creating separate courts. In fact, some existing family departments in the first instance courts have only 2 judges. For example, municipal courts in Dubrovnik and Pula, which under the rules applicable to the other types of disputes, it's not even enough for a division, because a division must have at least 5 judges working on the same type of cases. And in the end, I would like to add something that comes to my mind today that's not written in my paper. We are talking about children's rights, and that's great, we have to talk. But what about obligations that goes to the young people? Every young people have to have in mind, also their parents also, they have to respect other people, their colleagues, their friends, their parents, their neighbors, their teachers in the first place. I think we lost that. And that's the major problem nowadays. I don't know if everybody will agree with me, but we have to go a little back, again, a little back in past. Thank you very much.